Okay, so right now I'm going to give you a preview of Chapter 13, which is about the judicial system. We're going to go through lessons 1, 2, and 3. So first, lesson 1 is about the judicial system in our democracy. So it starts out with the principles of democracy and how the judiciary fits into that. 1, courts interpret the law. So the legislative branch writes the bills, passes them, sends them to the executive signs them or vetoes them, and then they become law. But then we just have a written law, and people will sometimes still argue about what that law means or how it should be applied. So that's where the courts come in. They interpret the law. This goes back to a famous, important Supreme Court case, Marbury v. Madison in 1803. There are a whole bunch of court cases that you'll need to know for the exam at the end of the year. This is one of them, Marbury v. Madison. It established the principle of judicial review, which says the courts interpret the law and can even declare laws unconstitutional. Courts also maintain what's called the rule of law, an important term there, the rule of law. The rule of law says that the law applies to everybody. In a lot of ancient monarchy systems, there was something called divine right of king that said that the king could never be accused of breaking the law because the king makes the law. Well, in our system, everybody's under the law, even the president. So the president can be accused of breaking the laws. For example, the Watergate scandal. This goes back even before our country to the Magna Carta. Magna Carta was an English document in the Middle Ages where the king signed and agreed to respect the rights of the nobles. So the king's power was limited in there. And of course our Constitution, the Constitution sets out the rule of law. The Constitution is our national law, the highest law, the final authority. Courts also serve to prevent the abuse of power. They do that through judicial review. So if Congress and the President pass and make a law that is unconstitutional, the courts can throw it out. And this is all part of checks and balances, which goes back to Montesquieu and Federalist Paper 51, checks and balances, where the courts are the ones who interpret the law. So an important part of our democracy. Judicial independence, another important aspect. The courts need to be impartial. We want courts and a court system, a legal system that deals with facts and evidence, not emotion, not personal biases or anything like that. So Federalist 51, in talking about the separation of powers, says that each branch needs to be separate from the others. So one way that works with the federal judges is they get something called lifetime tenure. Tenure means that they cannot be fired unless they commit a crime or do something wrong like that, in which case they can be impeached. But otherwise, once they're made federal judges, then they can do their job without worrying about politicians being happy or mad or whatever. So that gives them some independence, impartiality from the other branches. Federalist 51 mentioned that the government is Republican, which means that we have a representative democracy. We elect the House of Representatives. Indirectly, we elected the Senate, and we indirectly, through the Electoral College, elect the president. So we don't elect federal judges, but we do elect the president and the Senate, who nominate and appoint federal judges. So we have that indirect process still of our representatives choosing judges for us. But then again, there's the balance of power, or separation of powers, checks and balances, that once they're appointed, they do not rely on the Senate or the House or the President anymore. They are independent. Of course, they can be impeached, and they do still rely on funding from Congress, and they rely on the President for enforcement. The Supreme Court can make decisions, but they don't have a police force. They don't have a military to enforce their provisions, so they have to rely on the other branches. That's lesson 1. So then we get into lesson 2 on trials. There are 2 main types of courts and trials in the United States. We have criminal courts and we have civil courts. Criminal courts, of course, deal with crimes. You're accused of an actual crime. Civil courts deal with when you're accused of causing some sort of harm, in which case you're being sued and they're asking you to pay some money to help fix the harm. Courts have something called original jurisdiction. Jurisdiction is the region or issues that you have power over. Original jurisdiction means that this court has the first power, or is the first court that an issue goes to. So state courts are the original jurisdiction for state crimes. If you are accused of a state crime like burglary, then you're going to go to a state court. Federal courts have original jurisdiction for federal crimes. If you're accused of a federal crime, such as bank robbery or tax evasion or something like that, then you're going to go to a federal court. Federal courts also have original jurisdiction on issues between states. So if one state sues another, which might sound kind of crazy, why would one state sue another? But it does happen sometimes. For example, if there's a river running between multiple states and one state is doing something that's polluting the river and affecting the others, it would go into the federal court system. Okay, so in our courts, we have a system of process we call an adversarial system. Some courts around the world use what's called an inquisitional system. In an inquisitional system, the judge will interrogate the person accused and try to get information out of the person accused. In an adversarial system, the judge is more of an impartial person, just there to make sure the processes are followed legally. But instead, we have two adversaries, the prosecutor and the defense attorney. The prosecutor representing the state, trying to prove somebody committed a crime, a defense attorney representing the accused, trying to defend them and show that they're not guilty, or at least show that the state hasn't proved the person's guilty. That would be in like a criminal trial, and a civil trial would sometimes just call them plaintiffs and defendants. The plaintiff is the person suing, making the claim, and the defendant is the person defending themselves against the claim. The judge, again, is impartial in this adversarial system, and we also have a jury that should be impartial. And impartial just means they don't have any personal stake in the issue, they don't have any personal bias in the issue. Their job is just to look at the facts and make sure everything goes according to the rule of law and due process. So what is the trial process? Well, first, some Supreme Court cases you're going to need to know about include Gideon v. Wainwright. In 1963, this was a Supreme Court case that ruled that people have a right to an attorney. You have a right to be represented in court. Again, when we say Gideon v. Wainwright, just a side note, the first name is the plaintiff, the person suing. Okay, the second name is the defendant, in this case Wainwright. So whenever you see court cases there, that's just a side note, the first name is the plaintiff and the second name is the defendant. But in this case, Gideon had been convicted and wasn't represented in court, so he sued Wainwright, who was a representative for the state of Florida, and said that his rights had been violated because he didn't have an attorney. And the Supreme Court ruled in his favor and said, yes, everybody has a right to an attorney. But also, court cases besides the plaintiff and defendant, sometimes they're just called by the second name, like the Wainwright case, but there are exceptions to that. We'll say like the Brown decision for Brown v. Board of Education, or Roe for Roe v. Wade. But those are just side notes, so you understand when people say the Roe decision or the Brown decision, like that's what they're doing here. Another important case, Arizona v. Miranda. A few years later, 1966. This case, Miranda decision, said you do have the right to be told your rights. So if you ever see somebody being read their rights, you have the right to remain silent. Anything you say can and will be used against you. That's Miranda rights, and that comes from this decision. So two important decisions. Gideon v. Wainwright said you have the right to an attorney. Arizona v. Miranda said you have the right to be told that you have the right to an attorney and the right to remain silent and things like that. In the trial process, the vast majority of criminal cases in America never go to trial. Instead, they're plea bargained. A plea bargain is when the prosecution and the defense reach a deal ahead of time, usually for a lower sentence or a lower charge in exchange for a guilty decision. These are really controversial right now in our legal system. 97% of federal criminal cases are plea bargain, never go to trial, never see a jury. 94% of state criminal cases do this as well. And this is really controversial because there are accusations that our system has been corrupted over time so that certain abuses are happening and pushing people to plead guilty for things that they really shouldn't plead guilty for. Some of those abuses can be what's called charge stacking, and another one is called mandatory minimums. Charge stacking is when a prosecutor accuses you of a whole bunch of different charges related to one crime. So for example, I actually know somebody who was once arrested for one event, but charged with 8 different felonies. And then in the plea bargain, the prosecutor offered to take those 8 felonies down to 1 misdemeanor, which is a much lower charge, in exchange for a guilty verdict, or a guilty plea. And what this does is it tells the defendant they can either take this 1 misdemeanor charge and plead guilty and get a very minor sentence, or they can go to court and try to defend themselves, but they run the risk of being convicted of 8 felonies, which could get them many years in prison. So card stacking puts a lot of pressure on the defendant to take this plea because they're taking a huge risk. Now, why would a prosecutor take 8 felonies down to a single misdemeanor? Usually, it could be that maybe the prosecutor isn't really sure they have enough evidence to convict of 8 felonies. Maybe they're even adding felonies that don't really make sense, but it also could be something a little less bad, which would be something like saving the state money because trials cost a lot of money. So if you can get a plea bargain, it saves money. It could be that maybe they think that this person, even though they committed a more serious crime, maybe they think it was, a one-time thing and they don't really need to be in prison for years. So there are various reasons, but one of the accusations is that they're intentionally overcharging people, threatening them with many years in prison in order to get them to just take the plea for something simple. Mandatory minimums is when a charge, a crime, is sentenced a mandatory minimum number of years. So you might be accused of a crime that has a minimum sentence of 10 years. So if you get convicted at trial, you're going to go to prison for at least 10 years. Well, then the prosecutor comes to you and says, do you want to take that chance going to trial, or would you like to take this lower charge that doesn't have that minimum sentence and maybe you only get 1 year in prison, or maybe even not any time in prison? So lots of times people will take these plea deals. When they take a plea deal, even though they claim to be innocent, it's called an Alford plea or a best interest plea. So they are saying, I plead guilty, but they're also saying, I don't really want to say I'm guilty. I'm taking this deal because it's in my best interest to go ahead and take the lower charge because I don't want to take the risk of the bigger charge or the mandatory minimum or the card charge stacking. So this is really controversial right now, whether this is appropriate. Juries, we have juries, normal criminal or civil trial juries. We also have something called a grand jury. The term can be a little confusing because it sounds like it's like more important or something like that, but that's not really what it is. Grand juries are a little bigger, usually 16 to 23 people instead of average 12 people. But when a grand jury is created, it is a prosecutor isn't sure if they want to actually charge someone with a crime, if they really want to go to trial, but instead what they're doing is they're going to this grand jury, presenting the information and asking the grand jury, do you think I should charge this person with a crime? If the grand jury says yes, they should be charged, that's called an indictment. So they're issuing an indictment saying the person should be charged. When there's a grand jury, only the prosecutor's there. The prosecutor is presenting their evidence. There's no defense because this isn't a trial. It's just seeing if there's enough evidence to charge the person. So when there's a grand jury, usually it's going to end in an indictment because if only the prosecutor is presenting evidence, there's no defense at all, it makes sense that there's going to be an indictment unless the evidence is so bad that you don't even need a defense for it. So why would there ever be a grand jury? There's a few reasons. Sometimes if an issue is very politically controversial, and the prosecutor doesn't want to seem biased in the case, like they're going after someone for political reasons, they might go to a grand jury, because then if the grand jury issues the indictment, it kind of takes the pressure off of the prosecutor. That would be one reason. Or sometimes if the prosecutor thinks they have evidence, but they're not sure if it's enough evidence, they might present it to a grand jury and see what the grand jury thinks. Then, if there's an indictment, we'll go to a trial. But again, most charges never go to a grand jury. They just go straight to an actual accusation. And if there's not a plea bargain, then we go to a trial, usually a jury. Federal courts and criminal courts always have the option of a jury. And the option would be from the person being accused standpoint. So if you're accused of a crime, you can ask for a jury trial, which almost everybody would. Federal courts and criminal courts have those. Most civil courts, again, that's when you're not accused of a crime, but you're accused of causing some harm to somebody. Maybe it was a car crash or something like that, and they're asking you to pay their medical bills. Most of those will have juries, but some states don't guarantee those for civil courts. Jury service, last part here for this section. Jury service, when you get called and asked to be on a jury. This is a civic duty and a privilege. Our country relies on people serving on juries. We have a jury system for our trials. That means we need people to perform the duty of going and serving on a jury. And it's also a privilege because you get to be part of our system of ensuring fair treatment, the rule of law, those sorts of things. To be on a jury, you have to be a U.S. citizen, at least 18 years old. You have to understand English because court's going to occur in English. You have to be a resident of the place where the trial is, and generally speaking, not a convicted felon. There are a few jurisdictions that have an exception for that, but generally speaking, if you've been convicted of a felony, you can't be on a jury. There are times when you can be excused. For example, if it would create an unnecessary hardship. Okay, let's say you have a medical condition and going to the courthouse every day and sitting through this trial would be medically difficult for you. You might be able to get a hardship. If you're out of the area, let's say your driver's license is in Lakeland, so you get summoned for a jury in Lakeland or in Bartow, where our court is, but you happen to be going to college in Tallahassee. You could say, I'm out of the area, so you can get a postponement or an exemption there. Also, you do not have to serve on a jury if you are dead. Now that might seem obvious, but this is an actual picture of a jury summons for Polk County. And it says, you may request one postponement or excusal. You are ineligible by law to serve if you are not a United States citizen, you are a convicted felon, you are currently being prosecuted for a crime, or you are dead. And this form asks you to check the box and mail it back to them if you're dead. So if you are dead and receive a jury summons, you're supposed to fill out this form and let them know that you're dead, and then you will be excused, but only one time. Okay, so seems pretty obvious, but I guess it's just common courtesy if you're dead to let people know. So that's just a nice thing to do. So don't forget, if you're dead, let them know.